I am attorney Justin Sterling, a personal injury and business lawyer. This is Coffee with a Lawyer, streaming live on Facebook, LinkedIn, YouTube, Twitter, and Instagram. This is your chance to ask the lawyer your legal questions for free. And it's our chance to connect with you and the online community. This is why we do what we do, to help people improve their lives. We are the law firm you can go to when you need help in tough situations. And today, we have a special guest. So I'd like to invite Wayne to ask your question, if you may.
Thank you so much. Good morning. So I purchased a online course through Instagram back in September, on September 5th. Now, the reason the way I purchased it was through communicating with the seller via Instagram, and based on the sales pitch video that she has provided. And in this pitch, she promises bonus materials once I signed on. However, once I signed on the course, I realized that there's 2 bonuses missing. I reached out and was promptly given, told that, the course was transitioning, and yet, so there may be something not transferred over. So I was given, one of the items that was promised as the bonus material, whereas the other one I asked, and then they gave all sorts of reasons why that is not promised, that shouldn't be delivered, and even to the point that saying that was never the way it was supposed to be delivered. And I said, I can only go by your sales pitch. And based on the course descriptions in there, her intro video, it contradicts with what she says. So a lot of back and forth. She refuses to provide that one item of the promised bonus material. So I said, then I would like a refund. I don't want this. And the course was supposed to be for 8 weeks. At first, when I signed on, it was about like 5 weeks. So she was saying, I'm giving you more. Therefore, in reading between the lines, she's saying that, because we're giving you more weeks, therefore that doesn't account for that should account for the missing promised bonus item. So anyways, I asked for a refund. On September 25th, she gave me, the whole course was $1,500. She gave me $500. I said, that's not what I asked for, because what I find is the product that I purchased, that I received, was different than what was promised. Therefore, I would like a refund, a full refund. And she refuses, and I have not, because of family issues, I have not been able to deal with that until now. So that's a gist of, I don't know if I have a case, but I just wanted to pursue and see what my rights are.
Right. All right. Well, thank you. Good question. Couple issues. Let's address some foundational issues. You interacted with this other party via an online platform, Instagram, correct?
Yes.
So in this relationship, I would say the terms of service of the platform may control. All right. So I would be well versed on the terms, the service terms for Instagram, and what you can do and can't do on that platform, and where you can seek recourse if there's any abuse on their online platform. You may want to report the abuse, so to speak, or the wrongdoing to the platform, because this other party could, obviously they're using the platform for commercial profit and to possibly promote a fraud, if it is fraudulent.
That's what I felt like, yeah.
Or for breaching their agreements, a breach of contract. The sales pitch, does this create an adequate offer so as to create in your mind that if you accepted it, this is what you were going to receive, the benefit of your bargain. So the sales pitch, we have to analyze that. Was it certain, clear, and definite terms So to allow you to believe that if you accepted this, you would get something in return, and exactly what it would be in return. So you have to analyze the sales pitch. It sounds like it did elevate to the level of an adequate offer that created the impression on the buyer, you, that if you took these steps, you would have a binding contract. So it sounds like it was adequate. The missing bonuses, you can allege that they did not satisfy their side of the deal, that it was material to you entering this deal. So it's something that you expected to obtain.
Right.
And the fact that they did not provide that, they fell short of providing what they promised. So you could say that this was a breach of their side of the deal, a breach of contract. However, you really have to analyze the amount in controversy. $1,500 for the full course, $500 you got in return. So right now we're speaking about $1,000. You did receive some value. We don't know exactly what that value was, what you got in exchange, but you do want a full refund. All right. How many weeks did you participate in this course? It was originally a 5-week course. They gave you more weeks. I don't believe the fact that they gave you more weeks from your point of view is relevant. It's not what you contracted for. That wasn't the benefit of your bargain.
Right.
However, did you accept it? Did you actually take part in the actual weeks? Did you receive some form of legal benefit? Okay, so So to their argument, they can say that they expended a legal detriment by providing you these additional weeks, and you did accept it. So there could be some type of set off. I don't know, but for your argument, you didn't contract for this. This wasn't part of the deal. This is something they did gratuitously, and the fact that you actually received the additional weeks or not is not relevant. Your deal consisted of 2 bonuses, 5 weeks, and you didn't receive that. That's your argument. So you want to allege breach of contract, and you want to assert your possible remedies. And there are different remedies for breaches of contract. Expectation interest. What did you expect to benefit from this deal? That's your general damages. That's usually the more valuable damages. In this case, though, there may be better alternatives. There's rescission, there's restitution. Rescission is you want to put the parties in the place had they not made the contract. So it would be returning your fee and returning the product back to the seller. That would be an adequate remedy for this breach. I would say rescission. Let's rescind the contract, put the parties in the place had they not entered the deal. However, they may not be willing to do that because they expended some energy, resources, and money on you already. And they too expect to keep their benefit of the bargain, which is the $1,500. It's a difficult situation. One, because you're dealing with the platforms, a third party, you're doing business over a social media platform. So their terms of service control. However, it sounds like you took it off the platform and started dealing directly with the seller, correct? So you can, I don't know if the terms of service are very persuasive in this case because you took business off the platform. What would you like to get out of this? You want your money back?
So what I want to get out of this, that's a really good question. I think I because the terms of conditions that, so the course was sold through Instagram, but it was not conducted on Instagram. If that makes any difference. So basically she gave me a sales pitch and I read that and I watched it, and based on all the terms and conditions, I decided to go ahead and pay for the course. So it's dealing directly with her online academy, for lack of a better word. So there was no internet, Instagram condition. So I don't know. So everything any interaction she has made it clear to go through her associate. So that's what I went through. I went by her request, her what she wanted. What I want out of the course, I just and also when I requested, she just locked me out. So I have no access to the course as of September 25th when she refunded the money. Mm-hmm. So anyways, because the terms of conditions, I asked for what's your refund policy. I would go by what your refund policy is if you're unable to let me know what, if I take course in some part, then, however she wasn't able to. And what she gave me was a screenshot of whatever her advertisement was, which I never saw, saying no refund. So it's very shady. Unfortunately, I didn't learn that until I signed on, and I said, I just do not want to go ahead with this course. I want my refund because you're not able to provide me with the original terms. I said I never signed on to the additional courses. Mm-hmm. So that, if you try to argue that, and also when I said, so let me just be clear about this. So the bonus was one-on-one consultation, or not one-on-one, weekly consultation in addition to the weekly online courses that they have for 5 weeks. So they aren't able to provide that weekly. And they kept on saying, well, it's part of the Q&A in the online course. I said, well, it doesn't sound like that because it's very specifically clear saying, in addition to that, there's the weekly consultation. Mm-hmm. I said, I'm not asking for full 8 weeks. I'm asking for your original terms and conditions. I'm only asking for that. So when she couldn't provide that, that's when I wanted the refund. So at this point, I would love for a refund, but I'm open to, because it's just, I don't want to be unreasonable and ask for a refund, full refund if I'm also misunderstanding the terms and conditions.
Well, hang on. Wayne, it's a tough situation. In a perfect world, you would get your money back. All right. But you're dealing with a contentious individual. You guys are not seeing eye to eye. And the amount in controversy, relatively speaking, is de minimis. If you were to take any action, it would be a small claims action. Now, it sounds like you did not sign any official agreement. Did you sign any contract?
No.
Okay.
No.
Because in a lot of these situations, you'd be bound by an arbitration agreement, a waiver to join any class action. In your situation, I don't know how widespread they're doing business. I would suggest perhaps attempting to create a class, because $1,000, you're not going to get anywhere with your amount in controversy. But if you have wide exposure against the defendant, you could probably leverage that. That's why these type of businesses have you sign contracts which include arbitration clauses that prevent you from filing lawsuits and bind you to participating in a third-party resolution process known as arbitration. It's generally cheaper than going through the litigation process, and that's what these businesses would prefer. And they also, in their contracts, they would have a waiver of a class action, so you wouldn't be able to join any class. In your situation, it sounds like they did not have any formal documents of your relationship. So possibly you could gather other victims and increase the exposure to the business defendant so as to get the result that you want. But you alone, I don't think, have the time, energy, or resources to pursue this, and the recourse isn't there. You'd be spending a lot to just get something very small. So it's a cost-benefit analysis. Now, you're more than welcome. The courts are there for you. You can go ahead and file a small claims action. You could. You're not allowed to have an attorney in small claims court in most jurisdictions. You have to look at your local jurisdiction where you're at. That's another issue. You don't even really know where this other party is to pull them into court.
Right.
Yeah. It just, every situation is a learning lesson, and we can reflect back on this.
Unfortunately, yes.
Doing business on these social media platforms, you have to do due diligence. You have to know who you're dealing with. There's a lot of frauds, scams, and thefts out there. We handle it all the time. And in these situations, it does come down to the amount in controversy a lot of times. And the fact that you did get a partial refund, it shows some form of good faith on their part. So it's a tough situation. I would write to them demanding your full refund and laying out what we discussed here today. You can say, I would like to insist on having rescission of the contract and putting us in the position, had we not entered the contract, that means you returning the full amount of money. And if you do so, I will agree to release any claims and not pursue this any further. Otherwise, if we can't come to a amicable resolution, then I will have no choice but to seek the advice of counsel and possibly pursue a class action for those other people who have been harmed, who were in similar positions as me, in order to assert their rights on their behalf, and which would lead to much wider exposure on the defendant business. Does that make sense?
That does. Thank you. Because I also looked into what, my recourse. I was directed to, online, I was directed to the attorney, because I'm in California, the Attorney General's office for fraud or.
Okay, well, time out. Let's just put things, I hear all this and all of this is correct, and I agree, but we have to put things in practical experience. All right.
Yeah.
Practically speaking, the Attorney General. You think
that's what I'm like?
They're going to listen to you
right? That's why it's leading me down a internet rabbit hole of all of these, because I was just typing, recourses for consumers and all of these, and one of the.
Well, let me set something straight. All right. Yes, you are within your right contacting the Attorney General. I've done that many times in certain cases, but the cases are. Yeah. You may also you can also contact the FBI. This is done over the internet. This is a cybercrime. And I actually encourage you to report it to the FBI on their online submission. I forget what the URL is for that, but you can report cybercrimes to the FBI online. So I would encourage you to do that. You should put these entities on notice. But again, the amount in controversy is, relatively speaking, minimal.
Right.
I think in this case, your best action to achieve the result you want is to just write to her and say, look, let's resolve this amicably. I understand the amount in controversy is not much, but here's your leverage, Wayne. The leverage is the class action. That's when you'll get their attention. All right. You're not going to get the attention, please give me my money back. Please give me. You're not going to get your money back. You're not.
So I have an extensive amount of email exchanges with her, and that's what I also said. I said, which leads me to believe that I'm not the only victim, and I have no choice but to reach out to her. And she wrote back saying, "You're threatening me and everything."
Yes, you have to be careful. You must be careful. Your language, your tone, and choice of words are important in this situation because, yes, it could be interpreted as a threat. And in this situation, the threat would be considered extortion. So you have to walk a thin line when you're making legal demands. You have to proceed in good faith and with clean hands, always. All right, I would condition a lot of statements. This is not to be interpreted as a threat in no way, nor do I wish to pursue litigation at all, or do I even care to be part of a class action. I just simply want my money back. Rescission of this deal. I did not receive the benefit of my bargain. Okay. And if we cannot come to an amicable resolution, all right, you put the burden on her. It's not you making the threat. It's her choice. Her action will determine what you do. Okay. But you have to be careful. All right. Because yes, there is a thin line between asserting your rights and committing extortion. A lot of lay people, non-lawyers, don't understand this. And they just go around saying, I'm going to sue you. I'm going to sue you. No, you can't say that in our civilized society. You can't go around threatening lawsuits against everyone. You can't. You just can't. It's considered extortion. You have to have good grounds. You have to present it. And it is best to proceed in good faith, clean hands. And in these situations, I would go under attorney cover head. All right. Cover letter. All right. Have an attorney write it for you. Attorneys have a little bit more leeway in asserting legal lawsuits, because if there is an anticipated pending litigation, what the attorney writes under their letterhead and what they assert is protected by what we have as the litigation privilege. Common lay people do not have that privilege, and they can incur liability for extortion. It's serious. All right. When you make a demand, you have to be careful not to commit extortion. So that's why I needed to jump in and let you know, yes, she's correct. If she's saying you're threatening me, she's building her case. Cases are built. All right. And yes, you need the track record, you need your emails. But at the same time, that needs to tell you that this isn't going the direction where you want it to go.
Right.
You're in her ball game right now. You're just going to be emailing her for the next 1, 2, 3 years until you disappear. All right. So you have to come with the right language, the buzzwords to get her attention, to know that you consulted with counsel, you know your rights, and you know how to proceed in order to protect yourself.
Right.
So I would just keep it between you and her. And also don't start smearing her. All right. That's another thing, when you say that, I'm going to have to reach out and talk to other people. You have to be careful when you say that. All right. Because now you could be considered to be interfering with her business relations, her economic advantage, her, right. Keep your communications between you and the wrongdoer. Do not bring in third parties. When you bring in third parties, and you say, oh, well, I'm going to start telling them you did all this, did all that, you could be liable for defamation. All right. Trade libel, interference. These are serious claims, and you want to proceed carefully, because your amount in controversy, again, is only $1,000. With the actions that you're telling me, that, and you're probably not there yet, but it sounds like if you're not, totally informed, you could be. All right. And I don't want to see yourself get placed in a bad position, because all you were doing is protecting yourself and your own belief. All right. But you weren't totally informed. Don't bring in third parties. All right. Keep it between A and B. When you bring in third parties, you run the risk of incurring personal liability on yourself. All right.
Got it. No, thank you. That's really, really sound advice, and really
it's important. People don't know this.
Right. And so far it's only between the two of us. Okay. I knew the very last exchange of the email saying, this is the last. I think she has some kind of, maybe her legal team write that email on her behalf and just sending it. And I have not responded to that email. I just left it there. And I just wanted to seek out what my, the next steps should be. Because really I am weighing if I should just suck it up and just eat this and just chalk it off as a learning experience, or continue to pursue that. But it's just it's tough. Especially in this economy, during the pandemic, 1,000 is still 1,000. It's a lot. So anyways.
Yeah, in the grand scheme of things, it's not the largest amount, but it's still, a chunk out of your pocket. So I would insist, I would respond back to their last correspondence about outlining what we discussed, saying you did not receive the benefit of your bargain, regardless of the additional weeks. This is not what you contracted for. And all you want to do is put the parties in a place had they not entered the contract. Let's rescind the deal, give my money back. I'll return any product you sent to me. This just did not fulfill your reasonable expectations of what was to be provided.
Right. Right.
And then put the burden on them. If we cannot come to an amicable resolution, I will have no other choice but to seek legal counsel and possibly pursue a class action for those similarly situated who have been also wronged by your conduct. That's when you'll get their attention, because over $1,000, they'll keep telling you to kick sand over $1,000. But if you have $301,000,
right,
then they're like, okay, now we got to come to the table because we have more legal exposure here. And you can bring to their attention there was no formal written agreement that had any type of arbitration clause or any clause discussing class action. And you have reason to believe there are others similarly situated who had been harmed in the same way as me. Does that make sense?
Yes. Yes. Thank you. This is very enlightening and insightful.
Yes. The requirements for a class action is that there must be numerosity of plaintiffs similarly situated, and a likelihood of multiplicity of lawsuits. The same type of lawsuit being filed by numerous individuals against the same defendant. That's how you get a class action. But you have to go through class certification, which is a difficult process. Again, I don't know if this is something you want to take on. Maybe you speak to a class action attorney and you can serve as the class rep. There really are no special benefits of serving as the class rep, only that your name is on the pleading. Sometimes people don't want their personal name on the public record. Sometimes they do. They really, take it personally and want to pursue the matter and want their name on the caption on the class action. They're eager to serve as the class representative. As the class rep, you'll have to sit for a deposition. There is compensation as the class rep, but it's not substantial.
Right.
And it's a lot of obligations. You have to talk. You have to be the contact with the attorney. Your name's on the caption, and you're going to get deposed. You're going to have to sit for a deposition.
Mm-hmm. Mm-hmm.
So
no, thank you. This is really insightful and really helpful in me thinking, planning out the next steps.
Yeah, I would give it another round of communications. Let them know you consulted with an attorney. You're being, you want to be informed on your legal rights. You just want to come to an amicable resolution without the need of bringing in legal counsel and seeking the assistance of the courts. And make sure you let them know that you've been informed that this possibly could be a class action, because that's the only way you will get their attention. Make sense?
Yes, very much so. Thank you so much.
All right. So there are some people watching online. If you have a question, please put it in the chat. Do you have any other legal question while we're on? We have about maybe another 5 minutes or so.
I'm not at this point. Thank you. That's been friendly. So.
All right. Well, again, please use this as your weekly accountability meeting to stay on track, stay on progress, to stay informed on your rights. Keep checking in every Monday, 9 a.m. Pacific Standard Time, coffee with a lawyer. This is your opportunity to ask the lawyer for free. So I'm happy to be of service. I want to thank you for signing on, and wish you a good week ahead. Take care and take action.
Happy holidays. Happy Thanksgiving, everybody.
Yes, you too. Happy Thanksgiving. Bye-bye.